Title 11, Crimes Against Chastity. Chapter 1, Adultery and Concubinage. Article 333. Who are guilty of adultery? Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her, knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum periods. If the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Elements: 1. That the woman is married. 2. That she has sexual intercourse with a man not her husband. 3. That as regards the man with whom she has sexual intercourse, he must know her to be married. The offended party must be legally married to the offender at the time of the criminal case. Adultery is still committed even if the marriage is subsequently declared void. Cannot be prosecuted de officio. Each sexual intercourse constitutes adultery, formal crime. The gist of the crime of adultery is the danger of introducing spurious heirs into the family, where the rights of the real heirs may be impaired and a man be charged with the maintenance of a family not his own. U.S. v. Mata. Abandonment without justification is not exempting, only mitigating. U.S. v. Serrano, et al. Sheer necessity, mitigating. People v. Alberto, et al. A married man who is not liable for adultery because he did not know that the woman was married, may be held liable for concubinage. Della Fuerte. But the married woman is guilty of adultery. If she knew that the man was married, she would be liable for concubinage also. ID. Is it possible that one of them be acquitted? Effect. Effect of acquittal of one of the defendants. A. There may not be a joint criminal intent, although there is joint physical act. B. Thus, one of the parties may be insane and the other sane, in which case, only the sane could be held liable criminally. C. Thus, also, the man may not know that the woman is married, in which case, the man is innocent. D. Thus, also, the death of the woman during the pendency of the action cannot defeat the trial and conviction of the man. U.S. v. Della Torre and Gregorio. Even if the man had left the country and could not be apprehended, the woman can be tried and convicted. U.S. v. Topino and Guzman. Effect of pardon. Art. 344 required that 1. That the pardon must come before the institution of the criminal prosecution, and 2. Both offenders must be pardoned by the offended party. People v. Infante. Acts of intercourse subsequent to adulterous conduct is an implied pardon. People v. Muguruza, et al. Consent of offended party, ground for dismissal. People v. Cencino and Ramos. Agreement to separate, void in law tantamount to consent. People v. Guinakud, et al. Article 334. Concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse, under scandalous circumstances, with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prison correctional in its minimum and medium periods. The concubine shall suffer the penalty of destierro. 3 ways of committing the crime of concubinage. 1. By keeping a mistress in the conjugal dwelling, or 2. By having sexual intercourse, under scandalous circumstances, with a woman who is not his wife, or 3. By cohabiting with her in any other place. Elements: 1. That the man must be married. 2. That he committed any of the following acts. A. Keeping a mistress in the conjugal dwelling. B. Having sexual intercourse under scandalous circumstances with a woman who is not his wife. C. Cohabiting with her in any other place. 3. That as regards the woman, she must know him to be married. Who is a mistress? People v. Jesus Hilau, et al. Although Josefa Diaz lived in the house of the spouses Hilau, she was never considered as concubine of accused Jesus Hilau. She was voluntarily taken and sheltered thereat and treated as an adopted child by the spouses. She did not live, dwell, or remain in the spouse's dwelling in any capacity other than as a child or ward by the spouses. In view of this ruling, it is necessary that the woman is taken by the accused into the conjugal dwelling as a concubine. What is scandal? People v. Santos. Scandal consists in any reprehensible word or deed that offends public conscience, redounds to the detriment of the feelings of honest persons, and gives occasion to the neighbor's spiritual damage or ruin. The scandal produced by the concubinage of a married man occurs not only when, 1. He and his mistress live in the same room of a house, but also when, 2. They appear together in public, and 3. Perform acts in sight of the community which give rise to criticism and general protest among the neighbors. What is cohabit? People v. Patak, et al. Cohabit means to dwell together, in the manner of husband and wife, for some period of time, as distinguished from occasional, transient interviews for unlawful intercourse. Hence, the offense is not a single act of adultery, it is cohabiting in a state of adultery which may be a week, a month, a year, or longer. There is no concubinage if a married man is surprised in the act of sexual intercourse with a woman not his wife in a hotel. Chapter 2, Acts of Lasciviousness. Article 336. Acts of Lasciviousness. Any person who shall commit any act of lasciviousness upon other persons of either sex, under any of the circumstances mentioned in the preceding article, shall be punished by prison correctional. The preceding article referred to would have been the article for rape, however the same has been repealed and transferred to Title 8. This means that acts of lasciviousness is committed in the same manner as that of rape excluding carnal knowledge. Elements. 1. That the offender commits any of the lasciviousness or lewdness. 2. That the act of lasciviousness is committed against a person of either sex. 3. That it is done under any of the following circumstances. A. By using force or intimidation, or B. When the offended party is deprived of reason or otherwise unconscious. C. By means of fraudulent machination or grave abuse of authority. D. When the offended party is under 16 years of age or is demented. What is lewd? People v. Lazada. Lewd is defined as obscene, lustful, indecent, lecherous. It signifies the form of immorality which has relation to moral impurity, or that which is carries on a wanton manner. Abuses against chastity distinguished from offenses against chastity. Abuses against chastity, Art. 246. Committed by public officer. Mere immoral or indecent proposal made earnestly and persistently is sufficient. Crimes against chastity, Art. 336. The offender is private individuals generally. It is necessary that some actual act of lasciviousness should have been executed by the offender. Distinguished from attempted rape. Manner of committing the crime is the same. Offended party in both crimes is a person of either sex. The performance of acts of lasciviousness is common to both crimes. The differences are: if the acts performed by the offender clearly indicate that his purpose was to lie with the offended woman, it is attempted or frustrated rape. In the case of attempted rape, the lascivious acts are but the preparatory acts to the commission of rape, whereas, in the other, the lascivious acts are themselves the final objective sought by the offender. Chapter 3, Seduction, Corruption of Minors and White Slave Trade. Article 337. Qualified seduction. The seduction of a minor 16 and over but under 18 years of age, committed by any person in public authority, priest, house servant, domestic, guardian, teacher, or any person who, in any capacity, shall be entrusted with the education or custody of the woman seduced, shall be punished by prison correctional in its minimum and medium periods. The penalty next higher in degree shall be imposed upon any person who shall seduce his sister or descendant, whether or not she be a virgin or over 18 years of age. Under the provisions of this chapter, Seduction is committed when the offender has carnal knowledge of any of the persons and under the circumstances described herein. 2 classes of qualified seduction. 1. Seduction of a minor, virgin, 16 and over but under 18 years of age by certain persons such as person in authority, priest, teacher, etc., and 2. Seduction of a sister by her brother or descendant by her ascendant, regardless of her age or reputation. Elements of qualified seduction of a virgin. 1. That the offended party is a minor, virgin, which is presumed if she is unmarried and of good reputation. 2. That she must be 16 and over but under 18 years of age. 3. That the offender has sexual intercourse with her. 4. That there is abuse of authority, confidence, or relationship on the offender. Remember, virginity is presumed if the woman is unmarried and of good reputation, over 12 but under 18. If the woman is married and the offender knows it, having sexual intercourse with her is adultery. If the victim is less than 16 years of age, the crime is rape. If the victim is over 18, qualified seduction is not committed, in fact, no crime at all, if there is no force or intimidation or the woman is not unconscious or otherwise deprived of reason. Who could be the offenders in qualified seduction? 1. Those who abused their authority. Asterisk person in public authority. Asterisk guardian. Asterisk teacher. Asterisk person, who in any capacity, is entrusted with the education or custody of the woman seduced. 2. Those who abused the confidence reposed in them. Asterisk priest. Asterisk house servant. Asterisk domestic. 3. Those who abused their relationship. Asterisk brother who seduced his sister. Asterisk ascendant who seduced his descendant. Article 338. Simple seduction. The seduction of a minor, 16 and over but under 18 years of age, committed by means of deceit, shall be punished by arresto maior. The seduction of a woman who is single or a widow of good reputation, over 12 but under 18 years of age, committed by means of deceit, shall be punished by arresto maior. Elements. 1. That the offended party is 16 and over under 18 years of age. 2. That she must be of good reputation, single or widow. 3. That the offender has sexual intercourse with her. 4. That it is committed by means of deceit. The accused went to the house of his fiancée, her parents then being absent and availing himself of that opportunity, with the renewal of his promise to make her his wife, he succeeded in having sexual intercourse with her. Held, the accused is guilty of simple seduction. Deceit, the usual form of which being an unfulfilled promise of marriage is an important element of the offense. People be iman. Deceit generally takes the form of unfulfilled promise of marriage. Deceit consisting in unfulfilled promise of material things, no seduction. Article 339. Acts of lasciviousness with the consent of the offended party. The penalty of arresto maior shall be imposed to punish any other acts of lasciviousness committed by the same persons and the same circumstances as those provided in Articles 337 and 338. Fallback of qualified seduction and seduction had there been sexual intercourse. Elements. 1. That the offender commits acts of lasciviousness or lewdness. 2. That the acts are committed upon a woman who is a virgin or single or widow of good reputation, under 18 years of age but not less than 16 years, or a sister or descendant regardless of her reputation or age. 3. That the offender accomplishes the acts by abuse of authority, confidence, relationship, or deceit. With the consent of the offended party. This phrase is used in the title of Art. 339. The offended woman may have consented to the acts of lasciviousness being performed by the offender on her person, but the consent is obtained by abuse of authority, confidence, or relationship or by means of deceit. Both Art. 336 and Art. 339 treat of acts of lasciviousness. Under Art. 336. The acts are committed under circumstances which, had there been carnal knowledge, would amount to rape. Under Art. 339. The acts of lasciviousness are committed under the circumstances which, had there been carnal knowledge, would amount to either qualified seduction or simple seduction. There may be consent, but there is either abuse of authority, confidence, or relationship or deceit. Article 340. Corruption of minors. Any person who shall promote or facilitate the prostitution or corruption of persons underage to satisfy the lust of another, shall be punished by prison mayor, and if the culprit is a public officer or employee, including those in government-owned or controlled corporations, he shall also suffer the penalty of temporary absolute disqualification. As amended by Batas Pambanza BLG 92. Refer to RA 7610. Article 341. White slave trade. The penalty of prison mayor in its medium and maximum period shall be imposed upon any person who, in any manner, or under any pretext, shall engage in the business or shall profit by prostitution or shall enlist the services of any other for the purpose of prostitution, as amended by Batas Pambanza BLG 186. Refer to RA 7610. Also RA 10364. Chapter 4, Abduction. Article 342. Forcible abduction. The abduction of any woman against her will and with lewd designs shall be punished by reclusion temporal. The same penalty shall be imposed in every case, if the female abducted be under 12 years of age. Abduction is meant the taking away of a woman from her house or the place where she may be for the purpose of carrying her to another place with intent to marry or to corrupt her. Elements. 1. That the person abducted is any woman, regardless of her age, civil status, or reputation. 2. That the abduction is against her will. 3. That the abduction is with lewd designs. The taking away of the woman may be accomplished by means of deceit first and then by means of violence and intimidation. If the female abducted is under 12, the crime is forcible abduction, even if she voluntarily goes with the abductor. Sexual intercourse not necessary in forcible abduction. Forcible abduction distinguished from grave coercion. In both crimes, there is violence or intimidation used by the offender and the offended party is compelled to do something against her will. But no lewd design in grave coercion for as long as there is no deprivation of liberty for an appreciable length of time, otherwise, it is kidnapping and serious illegal detention. A, B, C and others grabbed a girl 15 years of age and then dragged her to a nearby forest. There she was brutally ravished, first by A and afterwards by B. What crime was committed? Held, the crime is not kidnapping with rape, but forcible abduction with rape. When the violent taking of a woman is motivated by lewd designs, as in this case, forcible abduction under Art. 342 of the RPC is the offense. When it is not so motivated, such taking constitutes kidnapping under Art. 267, People v. Crisostomo. Any subsequent rape, if any, separate crimes. Article 343. Consented abduction. The abduction of a virgin over 12 years and under 18 years of age, carried out with her consent and with lewd designs, shall be punished by the penalty of prison correctional in its minimum and medium periods. Virginity referred to in Art. 343 is not to be understood in so material a sense as to exclude the idea of abduction of a virtuous woman of good reputation. Thus, even if the accused had sexual intercourse with the girl before they eloped, there is still abduction with consent. But when the offended party had carnal knowledge with other men, her chaste character is open to question. Elements. 1. That the offended party must be a virgin. 2. That she must be over 12 and under 18 years of age. 3. That the taking away of the offended party must be with her consent, after solicitation, or cajolery from the offender. 4. That the taking away of the offended party must be with lewd designs. If virgin is under 12, it is forcible abduction. Consent of the minor to being taken away may be due to honeyed promises of marriage by the offender. Chapter 5. Provisions relative to the preceding chapters of Title 11. Article 344. Prosecution of the crimes of adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including both the guilty parties, if they are both alive, nor, in any case, if he shall have consented or pardoned the offenders. The offenses of seduction, abduction, rape, or acts of lasciviousness, shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor, in any case, if the offender has been expressly pardoned by the above-named persons, as the case may be. In cases of seduction, abduction, acts of lasciviousness and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices and accessories after the fact of the above-mentioned crimes. If by marriage, anytime. If pardon, must be given before the institution of the complaint and to both offenders to be effective. Underlying principle or reason why crime against chastity cannot be prosecuted de officio, the same is done out of consideration for the offended woman and her family who might prefer to suffer the outrage in silence rather than go through with the scandal of a public trial. Samilin v. CFI. Article 345. Civil liability of persons guilty of crimes against chastity. Person guilty of rape, seduction, or abduction, shall also be sentenced. 1. To indemnify the offended woman. 2. To acknowledge the offspring, unless the law should prevent him from so doing. 3. In every case to support the offspring. The adulterer and the concubine in the case provided for in Articles 333 and 334 may also be sentenced, in the same proceeding or in a separate civil proceeding, to indemnify for damages caused to the offended spouse. Article 346. Liability of ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. The ascendants, guardians, curators, teachers, and any person who, by abuse of authority or confidential relationships, shall cooperate as accomplices in the perpetration of the crimes embraced in chapters 2nd, 3rd, and 4th of this title, shall be punished as principals. Teachers or other persons in any other capacity entrusted with the education and guidance of youth, shall also suffer the penalty of temporary special disqualification in its maximum period to perpetual special disqualification. Any person falling within the terms of this article, and any other person guilty of corruption of minors for the benefit of another, shall be punished by special disqualification from filling the office of guardian. They cooperate as accomplices but are punished as principals. Title 12. Crimes against the civil status of persons. Chapter 1. Simulation of births and usurpation of civil status. Simulation of births, substitution of one child for another and concealment or abandonment of a legitimate child. The simulation of births and the substitution of one child for another shall be punished by prison mayor and a fine of not exceeding 200,000 pesos. The same penalties shall be imposed upon any person who shall conceal or abandon any legitimate child with intent to cause such child to lose its civil status. Any physician or surgeon or public officer who, in violation of the duties of his profession or office, shall cooperate in the execution of any of the crimes mentioned in the two next preceding paragraphs, shall suffer the penalties therein prescribed and also the penalty of temporary special disqualification. Article 347. Acts punished. 1. Simulation of birth. 2. Substitution of one child for another. 3. Concealing or abandoning any legitimate child with intent to cause such child to lose its civil status. The object of the crime is the creation of false civil status, or the causing of the loss of any trace as to the filiation of the child. Simulation of birth. The simulation of birth takes place when the woman pretends to be pregnant when in fact she is not, and on the day of the supposed delivery, takes the child of another as her own. The woman introduces a stranger in the family and defrauds the legitimate heirs. The woman who simulates birth and the one who furnishes the child are both responsible as principals. Substitution of child. The simulation of birth takes place when the woman pretends to be pregnant when in fact she is not, and on the day of the supposed delivery, takes the child of another as her own. The woman introduces a stranger in the family and defrauds the legitimate heirs. The woman who simulates birth and the one who furnishes the child are both responsible as principals. Substitution of child. This is committed when, for instance, X is born of A and B, Y is born of C and D, and the offender, with intent to cause the loss of any trace of their filiation, exchanges X and Y without the knowledge of their respective parents. The substitution may be effected by placing a live child of a woman in place of a dead one of another woman. Concealing or abandoning any legitimate child. 3 requisites must concur, namely: 1. The child must be legitimate. 2. The offender conceals or abandons such child, and 3. The offender has the intent to cause such child to lose its civil status. The unlawful sale of a child by its father is not a crime under this article, U.S. v. Capillo. He who places at the door of a charitable person a newborn child which is in a condition to stand the first inclemencies of the weather is supposed to do it in order that it may be taken up and protected, and, therefore, the legal presumption must be that he does not act with any other purpose than to cause the loss of any trace as to the filiation of the child. U.S. v. Capillo. When is abandonment of a minor a crime against security, and when is it a crime against the civil status of person? Article 276. A child is abandoned. The offender must be the one who has the custody of the child. The offender has no such purpose but instead to avoid the obligation of rearing and caring for the child. Article 347. A child is abandoned, their form of committing. The offender is any person. The purpose is to cause the child to lose its civil status. Illustrations. 1. A woman who has given birth to a child, abandons the child in a certain place, to free herself of the obligation and duty of rearing and caring for the child. What crime is committed by the woman? 2. Suppose that the purpose of that woman in abandoning the child is to preserve the inheritance of her child by a former marriage. What then is the crime? 3. Suppose the child, one day after its birth, was taken to, and left in, the midst of a lonely forest, and it was found by a hunter who took it home. What crime is committed? 1. Art. 276. Abandoning a minor. 2 Art. 347. Second PAR. Abandoning any legitimate child with intent to cause such child to lose its civil status. 3. Attempted infanticide. It is an attempt against the child's life. What constitute usurpation of civil status? The penalty of prison mayor shall be imposed upon any person who shall usurp the civil status of another, should he do so for the purpose of defrauding the offended party or his heirs. Otherwise, the penalty of prison correctional in its medium and maximum periods shall be imposed. Article 348. Usurpation of civil status of another is committed by assuming the filiation or the parental or conjugal rights of another. Thus, where A impersonates himself to be C, the son of another, and assumes the rights of C, the offender commits a violation of this article. Usurpation of profession is included. Thus, the offender who in the name of another, petitioned for the issuance of a duplicate of the latter's license as a professional, assuming the latter's person and profession, may be held liable for usurpation of civil status. It is absolutely necessary, however, in order to constitute this crime that the intent of the offender is to enjoy the rights arising from the civil status of the person impersonated. The purpose of defrauding the offended party or his heirs qualifies the crime. Chapter 2. Illegal marriages. What is bigamy? The penalty of prison mayor shall be imposed upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved, or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. Article 349. Elements. 1. That the offender has been legally married. 2. That the marriage has not been legally dissolved or, in case his or her spouse is absent, the absent spouse could not yet be presumed dead according to the Civil Code. 3. That he contracts second or subsequent marriage. 4. That the second or subsequent marriage has all the essential requisites for validity. Subsequent nullity of marriage, not a defense. Void or voidable marriage, before the same has been legally dissolved, not a defense. Before the absent spouse has been declared presumptively dead, bigamy may be committed. People v. Reyes. The second marriage must have all the essential requisites for validity, where if not for the subsistence of the first marriage. Thus, when the second marriage took place a day before the issuance of the marriage license, no bigamy. People v. Delara. Validity of second marriage is a prejudicial question to liability for bigamy. How about the second spouse? The second spouse is not necessarily liable for bigamy unless the second spouse knew of the first marriage, the latter is deemed an accomplice. The witness who falsely vouched for the capacity of either of the contracting parties is also an accomplice. Since bigamy is a public crime, either the first or second spouse may initiate the complaint. A person convicted for bigamy may still be prosecuted for concubinage. Article 350. Marriage contracted against provisions of laws. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who, without being included in the provisions of the next preceding article, shall have not been complied with or that the marriage is in disregard of a legal impediment. If either of the contracting parties shall obtain the consent of the other by means of violence, intimidation, or fraud, he shall be punished by the maximum period of the penalty provided in the next preceding paragraph. Elements. 1. That the offender contracted marriage. 2. That he knew at the time that a. the requirements of the law were not complied with, or b. the marriage was in disregard of a legal impediment. Illustration. A. who was already married to C. obtained a blank form for marriage contract, and having secured the signature of B on it without the blanks being filled, falsified the same by filling the blanks and making it complete with the signatures of the Justice of the Peace and of the local civil registrar. B insisted on a church marriage. A and B went to a priest, who, relying on the falsified marriage contract, solemnized the marriage. Held, this case do not involve a violation under Art. 349 because the second marriage being void for lack of marriage license, cannot give rise to bigamy. But A is guilty under Art. 350, because he contracted marriage knowing that the requirements of the law have not been complied with, to wit, he did not have marriage license when he contracted the marriage. People v. Peralta. Marriage between uncles and nieces, or brother and a sister, this is in disregard of a legal impediment. Marriage contracted by over 18 years of age but no parental consent/parental advice. Conviction of a violation under Art. 350 involves moral turpitude. Article 351. Premature marriages. Repealed by RA 10655. Any questions relating to paternity and filiation, refer to the Family Code of the Philippines. Article 352. Performance of illegal marriage ceremony. Priests or ministers of any religious denomination or sect, or civil authorities who shall perform or authorize any illegal marriage ceremony shall be punished in accordance with the provisions of the marriage law. The offender under Art. 352 must be authorized to solemnize marriages, otherwise, he is liable under Art. 177, Usurpation. A clergyman who performed a marriage ceremony, not knowing that one of the contracting parties is a minor, is not liable. U.S. v. Penalosa, U.S. v. San Juan.